Members, good morning. Happy New Year. May I wish you good health and every success in the new year. Please invite the administration to join us. Mr. James Doe, have you received the administration's reply?
好，各位官員早晨啊
！Good morning and Happy New Year to the administration. Good health and every success in the new year.
冇事。呢個咧就係佢，如果佢一陣搞得掂咧，佢會做埋 CSA， 但係讀英文啫。
好啦，因為我哋
We have met a number of times, and I will skip the introduction for the administration. So the first thing on the agenda is matters arising from the last meeting. The administration has prepared a paper in response to issues raised at the meeting dated the 21st of December last year, paper number CB1413/1718-02. Can I give the floor to the administration to walk us through the paper, please? Thank you, Chairman. Again, this is the beginning of a new year. Thank you for convening this meeting. Yesterday, we provided a written response to issues raised at the last meeting, and I like to highlight the important points in the paper. At the last meeting, some members asked about the requirement on the period of records to be kept. Currently, it is 6 years, and there is no objection, and we believe that it is appropriate. However, we noted that there are views in this BC that perhaps a better approach is to maintain records for at least 5 years, as recommended by FATF. So we are willing to accept this proposal from the administration, and so we will draft a CSA to amend the record-keeping period and has it reduced from 6 to at least 5 years. Because for DNFBPs, i.e. Lawyers, accountants, real estate agents, and trusting company service providers, can they be allowed to commission a third party to exercise due diligence for their customers as it is done by banks or FIs? We understand this, and we are willing to make amendments to the bill so that DNFBPs can have a third party to exercise due diligence requirements for their customers, because these are two main concerns of the BC, and we're willing to amend our bill in response to members' comments. And the letter is also on technical points raised at the last meeting, and I will not repeat them anymore. All right, any comments from members? Mr. James Doe, I thank the administration for giving favorable consideration to our suggestion, because if the requirement of FATF is for at least 5 years, we should follow their requirement. Then, because according to administration, they adopt a minimalist approach, so unless there's a need to go beyond the requirements of FATF, but the administration hasn't got any easing principle to make it 6 years. So I think we should follow the minimal requirements of FATF so that there can be a stronger consensus in the community. So the administration has accepted Mr. James To's suggestion. All right, if there are no other issues, we go on to the next agenda item. We should start from clause 18, and that is page 52 of the marked up copy. (53EZ). We should start with 53EZ. Yes, our legal advisor has got some points to raise. Before we go on, I'd like to follow up on 2 points in the administration's response. 5A, real estate. Now, according to the administration, it makes no difference whether the real estate is in Hong Kong or outside. So 53A has also made mention of real estate. I'd like to know whether the interpretation is just the same. Yes, that means real estate both within and outside Hong Kong is covered. Then perhaps is it possible to define real estate in the bill to state clearly that real estate could cover property within and outside Hong Kong? May I refer members to page 77 of the marked up copy. There is a definition for property in the bill, page 77. It follows more or less the definition adopted in Pt1. But here it says, money, goods, chooses an action in land, whether in Hong Kong or elsewhere. And now, this is not found in the definition in Pt1. So we cannot just use the definition for property in Pt1, or we should state clearly that it covers property in Hong Kong or elsewhere, because if it is not specifically stated, then property outside Hong Kong might be excluded. Since the administration has clarified, the real estate could cover property within and outside Hong Kong, so members may want to consider making it clear in the bill the real estate cover property both within and outside Hong Kong. Administration's response? Thank you. And thank you, legal advisor, for your suggestion. We have discussed with DOJ very carefully, and we have reviewed the real estate authority ordinance and also Pt1 here, and also we have drawn a comparison. Now the policy intent is for real estate to cover property within and outside Hong Kong, because the spirit is to carry out due diligence examination for customers. So the transaction has to take place in Hong Kong as regards the content of the transaction, and that is the property, whether it is within or outside Hong Kong doesn't matter. And this is not the essence of this bill, but it is our intention to cover property both within and outside Hong Kong, and we've drawn the reference to the presentation in the real estate authority ordinance. The authority has just issued a guideline for licensed real estate agents. They have to carry out due diligence examination for customers, even though the property is outside Hong Kong. So you see, the authority has jurisdiction over transaction of property outside Hong Kong. But for guidelines by the authority in the future, we were invited to clearly state that real estate cover property within and outside Hong Kong. And the important thing is the transaction takes place in Hong Kong. Mr. Kenneth Leung, I tend to agree with the administration, because we're talking about money laundering, and I think money, goods, and choses in action land, they should cover everything within and outside Hong Kong, and there is no need to refer to Pt1 because this ordinance is for counter money laundering. We have to understand the policy intent of this bill. If the real estate authority bill ordinance is not clear, then it should be revised. But here, money, goods, and choses in action and land within Hong Kong elsewhere is appropriate, and there is no need to amend it. Thank you. Mr. James To. Schedule 1 is interpretation. Usually, in clause 2, we have the interpretation section, but now it is in Schedule 1. Have they changed the style of drafting? Legal advisor, we have mentioned this a number of times. And I think that is their style of drafting and of this ordinance. They have put all the interpretation in schedule. For all bills, no, just for this, and also some other longer bills such as the copyright bill. It appears that for longer bills they have done that. No, I'm not talking about whether there are precedents. I'm asking a question of policy. Perhaps the law draftsman can explain. Speaker is off mic.
Such as the SF ordinance and this particular ordinance with long, very long interpretation provisions, it appears in a schedule to make it tidy, more tidy, but it is not a standard practice. It depends, it can vary from ordinance to ordinance.
Well, I don't know the reason for this treatment. Now, for Pt1, usually when people read a bill, there are only a few pages here. It's not, we don't have hundreds of pages here. Unless you have introduced new practice. Otherwise, over 99% of the ordinances have interpretation in the front, and now it's found in the schedule. Now, unless you have scores of pages for the interpretation section. Now, I have read some bills with a longer interpretation section, 5-7 pages, but they were put in the beginning of the bill. Well, now for Cap 615 is a relatively new bill. It was enacted in 2012, and back then there was a policy change, and when we have bills with a longer interpretation section, it would be put in a schedule instead of under clause 2. However, as our law draftsman said, we have different treatment for different ordinances. Sometimes when we amend certain ordinance, the interpretation will be in the front. And take the copyright ordinance example. The interpretation section is in a schedule. Legal advisor. Well, the interpretation is in a schedule. However, if you read Cap 615, there is Clause 2 interpretation or Section 2 interpretation, and here people will be referred to the schedule. Oh, all right, they have this reference. That's better. All right. All right. Now I have a question on the issue of property. Some colleagues are of the view that when it comes to anti-money laundering, we should not make a distinction between property in or outside Hong Kong, but we should ensure there is no extraterritorial jurisdiction. Will there be extraterritorial jurisdiction created as a result of the current approach? Thank you, Mr. To, for your question. We have studied with DOJ this issue. We believe no extraterritorial jurisdiction will be created because when a professional is approached by a customer to carry out some designated dealings, then he has to know the customer. Irrespective of where the property is and the jurisdiction the property is subject to. So the essence of the bill is whether he has exercise due diligence and know the customer.
So whether the property is domestic or overseas, they still have to conduct due diligence, and that does not lead to extraterritorial issues. So that is confirmed by the DOJ and us as well. I'd like to ask, as you said just now, you ask the clients and you have to understand them and you have to do due diligence and you understand whether they have overseas property. But is there any clause that says that the powers of the authorities, that describes the powers of the regulatory authorities? You have a, let's say you have the right, I can freeze certain assets, for example. Well, my understanding might be different from Mr. James To. So if you have a power to freeze, let's say they didn't complete the due diligence, and then you might have some powers to freeze certain assets. So if that is the case, then you will have extra powers. My understanding is we're scrutinizing the bill. It is related to anti-money laundering and the work that is relevant to due diligence, and Mr. James To's questions should be covered by other ordinances. I just want to ask that. Your understanding is correct, but the question I'm asking is, do we have these clauses in the ordinance? Hey, let's have the government answer. We can confirm that the answer is no. This ordinance does not have powers to freeze assets. Not just freezing assets. Says when the authority exercises its powers and when it deals with property, does the government have, or does the authority have certain powers that relate to property? And according to Part 1, there's a definition of property, but in Part 2 we don't have a definition for property, and it's the same for Part 3. So do they have the same definition? That would be my second question. So maybe our legal advisor can go through that, can run through that again and confirm that. Well, right now in Schedule 1, in terrorist financing and money laundering, the definition, it's in Part 1 of Schedule 1. and there is a description of property in the interpretation. Well, you talked about due diligence. Well, this is from the last occasion that we now, in our amended CSAs, we talk about due diligence. Okay, so in our amendment of due diligence, let's say we don't. Let's say one item doesn't require due diligence, and whether it's the government or the authorized law society or other professional bodies, they have a certain power, and because the definition of property has been widened, there's a mandatory power that extends to overseas jurisdictions under certain scenarios. That would be extraterritorial. No, the answer is no. The legal advisor's question is if a real estate agent, they help a Hong Kong client purchase an overseas property, so do they have to conduct due diligence? And our explanation is the property is overseas. That is not the problem. It's the provision of services, whether that is done in Hong Kong. And if it is done in Hong Kong, they have to do due diligence. So it's regardless of whether the property is domestic or overseas. So I can answer Mr. To's question on this occasion. Under no circumstances, and if they don't do due diligence, the government authorities can freeze the assets and such. That doesn't exist. Okay, I'll rely on that confirmation. If anything arises, at least I asked that question and you gave that response. Well, I want to ask about currency. We now have digital currencies, bitcoins and such. People say that that can be used as a tool for money laundering. So will this bill consider that, and can we plug loopholes relating to cryptocurrencies? We do have a new trend of cryptocurrencies. That might be one important loophole. How does the government respond? Thank you for the question. Cryptocurrency is something that we're focused on, we're keeping a close eye on, and we are thinking about how to deal with that. But currently in Hong Kong we have different laws that can deal with that scenario and provides suitable regulatory environment. So this bill doesn't deal with transactions of cryptocurrency. We're trying to deal with due diligence. So when a customer, they conduct cryptocurrency business, then the relevant professionals, the banks, need to understand the client's background and see whether there's any AML or TF. If there's any suspicion, they have to report suspicious transactions. Well, let's say there's a platform for cryptocurrency transactions, but they're unaware of such an event happening, and let's say there was money laundering. How do we safeguard the legality of the platform? How do we avoid breaching the law? Well, as I said just now, regarding cryptocurrencies, we have different ordinances that cover it. Let's say if there's financing, then SFC ordinance might be able to deal with that. If there's fraud, we have our criminal laws. We have serious and organized crime ordinances, or even the telecoms ordinance. According to the behavior, we can regulate these through the different laws that I mentioned. And as Chairman said, this is a new development, and we are keeping an eye on the global regulatory trends. And we're also looking at the IT development. We'll keep a close eye on developments, and we will come up with a suitable response. Also, in the future, if you detect a loophole, are you going to issue guidelines, or are you going to amend the law because lawmaking takes time. So if you do detect a loophole, how are you going to deal with it? Well, cryptocurrencies in Hong Kong, they are not a binding current legal tender, so we don't ban these activities. And we will use the different ordinances that I mentioned just now. If there's fraud, if there's dishonest use of a computer, if there's illegal financing, we can use existing SFC ordinance, SFO, and other criminal ordinances to deal with the different areas. So it has to depend on the facts of the case. We're also considering the overall direction. So different countries might have different approaches. Some countries will embrace cryptocurrencies, some might prohibit cryptocurrency. So we have to find our position, and this is something that we're considering. But we can ask you to rest assured, if there's any illegal activity, existing laws can regulate these activities. Well, the secretaries, we are focusing on due diligence, and Mr. Yu's question, I think that is a macro level question. It's not just about AML. There are other illegal activities that involve currency, and to put it more accurately, it might it's a currency. So in the future, the definition of currency, and that might be there might be a big difference with our existing understanding of currency. So we will need a comprehensive update of the definition of currency. So I think the government, the MA, they also need to keep an eye on development. Mr. James Toh? Well, might it have been included already? Because in part 1 of interpretation, we have a definition for money, and it says currency of any form, and in your new 5A, you want to regulate the different professions, the management of clients' money. So let's say Bitcoin, is that included? So let's say the lawyer handles Bitcoin transactions. So I'm just using that as an example. So does Bitcoin count as a currency? Well, if that is included, then we have money service and all that would be easy to handle. So the government, does it mean that we can't that Bitcoin can't be covered by the definition of money? Well, this is important, Chairman, because I think it's related to, let's say all of a sudden somebody gives an instructions of handling 10 Bitcoins. So the government, could you shed some light? Well, thank you, Mr. Toh. Customer due diligence, it's regardless of the transaction content. So no matter what business they are engaged in or what the transaction is about, as long as they are a professional's client, they have to do due diligence. So regarding money and currency, under AML, it refers to legal tender. So regarding currency exchange, we have a definition of currency exchange services being conducted in Hong Kong. Let's say Hong Kong dollar converted to non-Hong Kong dollar. There is a definition for currency there. Well, the question wasn't answered, Chairman. You're saying due diligence targets customers, but we must have a transaction. We have 5 ABCD. the managing of clients' money. Let's say they are given a Solidus firm is given 100 bitcoins to handle. So that is that would come under Part 1 of Schedule 1. 5A, would that be Part 2? And then money, the definition of money means money in whatever form or currency. So let me ask you, let's say a solicitor is dealing with money and it's just bitcoins on the client's behalf. So so when you handle clients' money, does that cover bitcoins or not? What's the definition of Bitcoin in Hong Kong? Let's set aside money service. Let's just talk about money. Does that include Bitcoin? Thank you for the question. Actually, when we drafted this legislation, Bitcoin was in existence, and I don't think they wanted to include Bitcoin back then. So that means you have to consider everything that has been said relating to Bitcoins. Well, I think Mr. James Toe's questions should raise some red flags in government's mind. The MA's future development would have to deal with Bitcoin. Well, we're trying to implement UN regulations, and I'm not saying we have to deal with it here. I'm saying Hong Kong's overall development, they have to keep an eye on Bitcoin. If there are any loopholes for criminals, we don't want to see more fraud cases. Well, we have to come back to our original question. There's no definition for real estate, and then but there's a definition for property. It includes overseas property. So the government stance, will they come up with a CSA and include overseas property definition for real estate? I don't think that's what the legal advisor intended. They will not change the law, but they will spell it out in the guidelines. No, Chairman, that would not suffice. There's a presumption, there's an assumption that everything is done in Hong Kong. But if 5A, well, the real estate agent is not covered here. Well, let's deal with accountants and lawyers in 5A. They talk about real estate. But if that does not include overseas property, because you've not added that, then the law society or accounting association cannot include that. That would be ultra virus. I don't quite understand what Mr. James Toe is asking. Your previous question and current question don't quite align. You were concerned about extraterritoriality. Allow me to finish my question. You were talking in the previous question. You were talking about extraterritoriality. In your previous question, that was just in general. But now you're saying if the ordinance is not clear, if there are overseas issues, you're saying that this drafting can't deal with it. Well, because if you didn't include overseas, then we can't deal with that. But then if you say overseas, then it would be extraterritoriality. Well, it's whether you have that, but now they said that there's no overseas property is not included. I'm sorry, Chairman. We are used to these kinds of questions. Let me clarify. In 5A, it includes real estate, as the legal advisor said. So my first question is, real estate, from your perspective, from a legal perspective, does it include overseas property? So do lawyers have to deal with that? And if this real estate, if the legal definition doesn't include overseas property, and you've chosen not to give a definition for overseas property, then you can't tell the Lawyer Society or the Accounting Association to include overseas property in their guidelines. That would be ultra-virus. So can you respond to these questions again? Secretary? Well, as said previously, the transaction is not what we're trying to regulate. We're just requiring the professionals who are providing the professional services to understand their clients, to do due diligence. So our intention is that whether the property is domestic or foreign, we still require the professionals to provide due diligence. So if members want it to be clear, there should be a description. So whether it is domestic or foreign property, would it be covered? We are willing to go and look at that. Well, Chairman, I feel that if you're just copying the UN requirements, because we refer to as property, and the UN, if they include overseas property, then I think you have to add that in the CSA. So the government has already promised to consider your question. The assumption is if you understand the UN requirement is that for professionals, when they deal with real estate, if the UN requirement includes overseas property, then we need to we have to comply with that. I think you also need, it's not just understanding, you have to clarify that as well. So they all have to do their job. They tell us that is their understanding, and if we don't have any opposite understanding, we'll have to just comply with that. Okay, so let's continue with clause by clause scrutiny. So the same principle. 5A is talking about legal and accounting services. You'll have to consider real estate services together with that.
So, shall we continue with our clause by clause? Well, thank you, Chair. We come to page 52, and this is about the disciplinary powers of the registrar. And 53Z is about the disciplinary action by the registrar and situations where the licensee contravenes a requirement set out in Schedule 2, and there may be penalties of over 500,000. And then we go on to the next page, page 54, and that is in exercising disciplinary powers, a registrar will have to provide notice in writing. And 53ZB talks about the guidelines for imposing pecuniary penalty by the registrar, that there will be consultation beforehand. Hold on, I think there's a question here. And Mr. To has a question. Mr. Chair, I have a question. On the licensing, and if there is a refusal of the licensing and then there is an appeal, would there have to be immediate cessation of the business? Well, I think it is in paragraph 11 of the response of the administration answering your question, which was raised in the last meeting, and it is in clause 75, and it says where there is an appeal, the license will not be suspended until there is a decision from the appeal. So that is to say the license is still valid during the period of appeal. That is correct. Well, Mr. Chair, in that case, let me continue with my question. Is this the first time of refusal? And that is, there is an application of license, and then there is an application for the extension or continuation of the license. Which scenario are you referring to, please? Both.
for either situation, during the appeal period, the license is still good. Well, in that case, you should have said the same in the meeting last time when I raised this question. Because in the last meeting, when I raised the same question, you said that the license will not be good. That is, the license will be suspended during the appeal period. That's what you said, and that's why I said whether there can be any grandfathering. Well, if this is your answer now, fine, fine, if this is your answer now. Mr. Chair, 53Z provides the disciplinary powers to the registrar, and that would include payment and or penalties payable by the licensee. I'm referring to bracket 3 and bracket 4 under 53Z, and the penalties mentioned here are $500,000 and $10,000. I would like to know whether this goes to the treasury of the government or to the management fund or operation fund of the registrar. Well, the answer was from the government, the proceeds will go to the registrar. But let me just look. 17A of the all penalties should go into the treasury as general revenue. That's from the company's ordinance. And I'm also looking at Cap 106 Telecom's ordinance. And it also mentions penalties. These penalties shall be forwarded to the government, it says here. So my understanding is that these penalties should not go into the coffers of the registry, but to the treasury of the government. So can you please explain when will the penalties be given over to the regulatory bodies as operation expenditure or income, please? Well, if we look at page 146, which we will go through later on, there is an amendment concerning the registrar and its operation funding. And it exactly responds to this issue, and that is the licensing fee will be part of the operation funding of the registry. So in the future, where there are penalties received because of licensing, this will go to the fund as well for the registrar. And we have already checked this fact with the Treasury, and they confirm that this is in line with the legislative intent. Mr. Chair, I understand that the bill says so, but why under the telecoms ordinance, even though OFCA does have their own operation fund, of course, why the penalties would go to the Treasury instead? Well, is that ordinance related to this? Legal advisor, please. Well, concerning this, because different funds were set up at different times, and at the time the policy intent was perhaps different, and I'm not able to say what the consideration was and the design was for the telecoms ordinance and the funding of OFCA. But for this ordinance, we are intending for the penalties to be given over to the registry, and we have confirmed with the Treasury Department of the government to say that this is in line. But of course, we can provide a written submission concerning the policy and whether this is left pocket to the right pocket. Mr. Chair, I think this is complicated because this is licensing, isn't it? The licensing fees, for instance, let me think. Yes, it is user pay, isn't it? That's right. But for penalties, it is different. And there are some bad precedents, if I may say so. And that is for the penalty mechanism, would the regulatory body consider its own financial situation in meting out penalties? Well, that's right. Well, the chairman is making it clear. That's right. If the regulatory body is in certain financial situation, would it be more strict in meting out penalties? Of course, I do not think you will do that. But do think about it. Consider this. This penalty mechanism. Would it or would it not be problematic? Now, Mr. Chair, of course, there can be different ways of thinking about it, but if you can, because we do have a little bit of time, if I may put this question to you, and that is, if you provide this power to the registrar, it may be kind of strange, but if you can give us some precedents or other examples, and we would not be overly worried, or we may come to think that there is no grounds to be worried. Right. But, and OFCA, they are in a more dire situation because there is a constitutional judicial review saying that they are too onerous, and the penalties or the fees may well run into the tens of millions of dollars. So OFCA is in a difficult position. You may have noticed that some people would say that this is a really staggering situation. So regulatory bodies and their situations, would you please consider this further? Mr. Ho Kwan Yew? Yes, I have a similar question. I would raise this to the administration concerning the penalties, fees being collected and kept by the regulatory body. I would like to know what are some of the, if you can give us a table as to what the existing situation is with regard to regulatory bodies. Now for CAP 2, in fact, it's all government, isn't it? And whether the licensing fee, for the fee to sustain the operation of the regulatory body, I can understand that. But for penalties to be used as funding for the regulatory body itself may attract all kinds of suspicions and criticism, such as unreasonably penalizing for proceeds reasons. So, also if there can be a more appropriate arrangement according to the fiscal year, let's say the filing fee, application fee, licensing fee, that's fine. But for this little piggy bank to be kept with inclusion of penalty payment, that would not be right. So if this is a trend or this is a direction the administration is going along, then I would like to know whether this sets a precedent, or how avant-garde are you? That is a question. Well, I think you have heard us. Lecture members are concerned about this issue. This is a policy consideration on the part of the government. What is the attitude of the government concerning this? Because indeed, I would think for the future, I think this will be impactful to in a more general sense to society going forward. Yes, we can go back and think about it. 53 set C, registration of pecuniary penalty order. 53 ZD, concerning the disciplinary powers in respect of directors of corporations. 53ZE, concerning appointing authorized officers for the purposes of the division, and 53ZF, concerning the magistrate's warrant to enter premises. 53ZG, concerning power to require production of material in legible form for information or document or records. 53ZH starts Division 7, which is about confidentiality requirements, and that is in the enforcement, the persons involved will have to keep all information confidential, 53ZI confidentiality, and 53ZJ permitted disclosures by specified persons due to judicial procedures, etc. There is a question here. 53ZJF. This is about disclosure of information, and it talks about judicial or other proceedings where there can be disclosure. There had been a clarification with the administration, and these proceedings are applicable to any judicial or other proceedings, not proceedings arising or stemming from this particular bill. A disclosure to whom, please? The relevant case where it pertains to other enforcement divisions or departments, then the registrar can provide the information to these departments or to the public. I mean, can the administration be clear or explain? Well, 53ZJ is about permitted disclosures by specified persons under judicial or other proceedings. Let's say that would be a situation where the court decides that there should be disclosure information, or the judiciary orders that there should be disclosure of information. For example, for money laundering, it may pertain to serious crimes ordinance or terrorist ordinance, anti-money laundering ordinance, etc. So it is not just for this particular ordinance, but other relevant proceedings as well, judicial or other proceedings. Well, that is fine. We can proceed. Page 62. 53ZK concerning permitted disclosures by registrar, and these will have to be based on public interest, and these will have to be appropriate before there can be disclosure of information. We go to page 64. Hold on, there is a question. Supplementary information. Under KD, it does not include the Real Estate Agents Association, the estate agents. Authority. Well, Chair, this is about a custodian or company licensing situation, and we see the estate agent's chance of operating these is very low in probability, and the estate agents and their relevant services or businesses would not probably merit this kind of disclosure of information given the parameters of their operations. And this is mainly in considering disclosure of information. We are rather stringent and conservative, and basically it has to be on the basis of public interests. And well, actually, Chair, we have had correspondence about this. For real estate agents, for them to operate custodians or companies that may be rare. But on the other hand, there are people in Hong Kong who may purchase properties outside of Hong Kong, and there may be TCSPs, and some people would, if it is alleged that the two parties, a buyer and the estate agent, are conducting money laundering, in this kind of a situation, should not the registrar also have this power to release information or disclose information to the EA? Mr. Chair, as mentioned, that was the reason why, as I have explained, why we have not included the real estate the estate agent's authority, but on the other hand, we can consider further. Now, Mr. Chair, public interest was mentioned. 53 ZKC, it says, if the information relates to the disclosure of information with consent of the person from whom the information was obtained or received. And if the information relates to a different person, with the consent also of the person to whom the information relates. So it seems that there needs to be a consent of the person concerned before there can be disclosure of information. Please explain. Well, thank you for the question. This is about a third person, where information is obtained from a third person and the information pertains to the second person. Then it is only appropriate that the person concerned will have to give consent before we disclose the information. But even if there is no consent, the registrar can, by 53 ZK1, disclose information nevertheless. And the registrar does not need to disclose the information concerning the person, but under public interest consideration, he can do so. What are you saying? That without the third person's consent, there can not be disclosure of information to the second person? And where it is about enforcement of the law, including other enforcement departments, then there can be disclosure of such information to these enforcement departments. Right. Where the other enforcement departments need the information, yes, there can be disclosure of the information to these departments. Right. My understanding is correct. Now we go to page 64.
53 ZL, miscellaneous. The Registrar of Companies may amend Schedule 3A, which is about fees, and 53 ZM, regulations. The Registrar may make regulations for a better carrying out of the provisions and purposes of 33Z. 53 ZN. A person commits an offense if he provides false statement or information. And then 53ZO, time limit for prosecution is 12 months. 53ZP, the registrar may ask for authentication of certain documents and instruments. We go all the way to page 69. Part or Division 9, transitional arrangements for trust or company service providers. 53 ZQ. We have said a number of times how the transitional arrangements should be. There will be Mr. James Teo. 53 ZO. Time limit for prosecution is 12 months. But this is about 12 months. Within 12 months after the offense is discovered or comes to the notice of the registrar. Is it a new way of drafting? Usually it is within 12 months after commission of the offense. It used to be like this. So because I won't know when the offense is discovered or comes to your notice, that means it's like eternity. So I filed you an offense, and you, theoretically speaking, should have noted the offense, right? Thank you, Mr. James Teo. We have made reference to the relevant provision in the Money Service Ordinance. Legal advisor, can you tell us how this is being dealt with in other legislation? Yes?
Chair, may I supplement? There are many similar provisions in other legislation, and there is case law also as to when an offence is taken to be discovered by or comes to the notice of a person. There is case law to that effect also. Because this is not an uncommon provision. There are many. It's already in section 53 of the anti-money laundering ordinance, a similar provision. Yeah, that's for money services, and these are and many other ordinances will have similar provisions, and it also operates. And there is case law on how it operates. Yeah.
Chairman, yes, Mr. Toh. On balance, I disagree with this drafting. I understand that you have precedence in other legislation, but usually for licensing matters, well, there are thousands of them. And most of them, the time limit for prosecution is 3 years or 5 years or 5 years within the commission of the offense. But if it is about whether the offense is discovered, then it can be a very minor offense, and yet it can haunt the person concerned forever. And I don't think this is appropriate. I find it problematic. I know that you might have precedence, but I want to ask you to see whether you can change it to, say, usually it's 2 years or 3 years. Yes, I get your question, but I have a different view. Well, it's not that after you have committed an offense, you can be clear of it after a certain period of time. Well, once the offense is discovered, an investigation can be launched, and then I agree that there should be a time limit. It doesn't matter, Chairman, you're entitled to your views, but I want to say that this formula is not adopted in most of our legislation, but there are precedents. Yes, I know I'm referring to minor offenses. When it comes to murder, of course, there should be no time limit. Well, I don't know whether money laundering is serious or not. No, this is not about money laundering. It's just filing. Well, but this ordinance is about money laundering. Well, you're entitled to your view. I have a different view from you, Chairman. Can the administration record that there are two different views? Yes, I want the administration to consider that I may not have the same view as the Chairman, and the administration should decide what to do. I may have moved a CSA. All right, page 69. 53 ZQ transitional arrangements is 120 days, and during the period, a license application would deem to be operating with a license, unless the registrar decides not to grant your license or review or reject an application for review. Transitional arrangements. Does that mean that if it is already licensed, then it will not apply? Well, that we don't rely on 53 ZQ. It's section 75. All right. Page 70. Part 6. Page 71, Part 6. Anti-Money Laundering and Counter-Terrorist Financing Review Tribunal. This is just a technical amendment. This is about the tribunal. Since we have reviewed the scope of the tribunal to cover other companies, so we have amended this part. We will amend the name of the tribunal, and the jurisdiction is expanded to include decisions by the registrar. And 5A. is excluded because the register has another power to make regulations. And the way the registrar can give notice, and that is under Division 1, Part 6. Amendment to 80, to Section 80. Now there is 1A. The registrar is allowed to transmit documents by electronic means, but if you look at 1, for money service operators, that is not allowed. It has the notice must be made by post and not by electronic means. Can we allow the Commissioner for Customs and Excise to do the same in order to catch up with times? Thank you. For money service. For the money service trade, it is a more traditional industry. And it's found that basically they are using very traditional means of serving documents, for instance, serving it in person, and there is no requirement that electronic means can be used. But of course, if it is found that the industry has this aspiration, we are happy to introduce such an amendment. Have you consulted the Customs and Excise Department on this point? So they still want to use a traditional means of transmission of document. Yes, the industry is submitting applications in a more traditional way. Chairman, I think this is about fulfilling our requirements under UN, so I don't think we should make other amendments. Uh, 80 on page 75, 1A. So if you say that it must be by electronic means, does that mean that as soon as it's transmitted by electronic means, it is deemed to have been served? Does that mean that the application must be submitted by electronic means? But of course, some may not have a residential address. People can operate using just a computer, sitting in a cafe. But if there is a residential address, you know, we have hackers nowadays. And if the system is hacked, you don't know how serious the consequence can be. If a person feels that it is safer to do it by post, or can that be allowed, or will we just provide convenience for the registrar? Now, in particular, we'll talk about notices to require further document or to introduce a penalty. Well, this is serious. Even the chairman said that this is a serious offense, and the time limit, the 12-month time limit should be counted at the point of discovery. Now, if the electronic or the email is accidentally deleted by the employee, that it can be very dangerous. Thank you, Chairman. Thank you, Mr. To, for your question. This is just an option. This is to provide an additional option for documents to be served or submitted by electronic means. If we look at 1A, in fact, for most of the time, the registrar would send notice or other document to the business address by post. This is the most secure means. And under E, if an applicant insists on serving and submission of document by means of electronic means, then we agree that this can be an additional option. So it is for the licensee to choose, right? It's not the decision of the registrar. It is rather the decision of the applicant. And where can we see this? I believe for most occasions, the applicant would submit a business address, and then the registrar would send a notice or other document by post to the business address, unless an applicant demands that such documents should also be served by electronic means. By providing an electronic mail address, then the notice should also be sent. No. You are using the conjunction or. That is in parallel, right? Unless you have a certain preamble, then if, for instance, a business address is not supplied, then an electronic mail address can be used. But this is not your presentation here. Well, our policy intent is to provide an additional option, but we've heard Mr. James To's comments, and we can make clear the guidelines. No, please don't refer to the guidelines. Now, this is the law, and because the conjunction here is or. Now, if it is your policy intent to provide an additional option, you should reflect it in E. You should amend E. Oh, all right. We can consider that. All right. Thank you. So the option is to be exercised by the applicant, not the registrar. Or if only an electronic email address is applied, well, it's because some people may just do business using a computer. Page 76, Schedule 1, Interpretation. Amendments and also additions of definitions. On page 78, we have a definition for trust or company service, and page accounting professional, page 81, director, and DNFBP, real estate, so on and so forth. We're following the definitions in the relevant legislation for regulating the professions. All right, if there are no questions, schedule 2, page 85. Requirements relating to customer due diligence and record keeping. I have a question here. Page 78. Returning to page 78. Nowadays, they have this mode of business. Secretariat company. No services provided. For instance, they have an address that serves as a letter box. For instance, in Causeway Bay, there is a commercial building. So you can print on your name card that your address is, say, flat 3B of a certain office in Causeway Bay. But no service is provided. It just serves as a letter box. But the conjunction here is or. Provision for companies that only provide a business address, then they will be regarded as trust or company service here. The net is too wide because we have hundreds of thousands of such companies. Now, this is about trust or company service. For what you mentioned, I think that related more to company service. So if an address is provided, there are many secretariat companies. No, I understand those. I want to address the scenario when no service is provided. apart from providing address. So you only receive letters by means of that address. You know, they have boxes, they have letter boxes. They cannot be regarded as trust or company service providers at all. Now, if they are to be covered, then I object as a matter of principle, because your scope will be too wide. Then I think you're asking people not to provide this service. And secondly, out of the blue, we have hundreds of thousands of trusts or company service providers, and they ask the registrar to give them a license. And if you conduct regular inspections, it's a waste of time. That would be, the scope would then be inappropriate, because, you know, there are such companies providing such services. Under C, Mr. James Toh, this is following recommendation 22 of FATF, providing a registered address, blah, blah, blah. So it is a direct copy from FATF recommendation. Now, it is just my view. It is rather silly. But you have considered all options and you cannot think of a solution. There can only be two possibilities. All right, if it must be so, so be it. If an international obligation makes it impossible for such a service to be provided, and these companies have to apply for a license to operate trust and company service, we have no other choice. But I've made my point, and I think this is silly, and this is not the right way to regulate such companies. But if you're of the view that you have no way out, you have to do that, then so be it. I rest my case. All right, you please provide a response later. We will do so in writing. Okay. I've seen such companies, but they are just like letterboxes or service offered by Hong Kong Post.
But the post office doesn't require a license. These services, they need a license. But since the the post office is part of the government, they are operating a business, but the post office doesn't require a license. But the company, they would need a trust company license. That's where it's ridiculous. So it's like the post office, they allow a P.O. box, so people can collect letters. Then they need a business registration. It's not just a business registration. They need a special license under the AML. Do they need a license? I'm not too sure. It's not clear. Chairman, let me give you an example. Chairman, the FTU has a lot of affiliated, let's say they have 100 affiliated offices, and they can give you an address on Ma Tau Kok Road, and now they would need a trust company license. That is possible. So the government, you need to think about it. Society, there are some complications in how things work. So moving to page 84, the record keeping for due diligence. The amendment is rather simple. Essentially, we're taking Schedule 2, the customer due diligence requirements. We're extending it to the non-financial business professionals, the DNFBPs. There are also some miscellaneous amendments to make it more readable. For the beneficial owner, there's a definition. We had mentioned in the beginning. We have a similar amendment. So not less than 10% of beneficial ownership. We're now relaxing it to 25% to define it as a beneficial owner. That's on page 86. The next amendment, under some high-risk scenarios, when a person is not present when the due diligence is performed, we don't require confirmation of extra information. We just want them to provide to take the relevant measures, and that is on page 100. We have a lot of similar amendments. The text reads quite similarly. It takes some time to flip to the page. Clause 9 of Part 2. So when the client is not present, special requirements when customer is not physically present for identification purposes, they need to confirm all the information submitted, and on this occasion we suggest that we don't need all the information to be confirmed again. It's just that they have to take some extra measures to confirm the information. So my understanding is that theoretically, so what hasn't been obtained, you don't need to further obtain it because the person is not present, or even if the customer is not present. So if the customer is not present, they have to confirm what they already obtained, but they're not present. You require certain extra information and you write them a letter asking them to provide it. This is just because of developments in technology. When we have a high-risk scenario, that is a customer, aside from their identity, we ask them for the ID, and we take extra steps. We register their travel documents, and then according to 9B, all the information relating to the customer that has been obtained by the financial institution or the DNFBP, we now have facial recognition, voice recognition, or we even have third-party IT platforms. We can get credit rating information. That can be used for verification. So under these circumstances, let's say for facial recognition or voice recognition, if we use 9B, that cannot be done. We cannot confirm everything. So we want to relax that a little bit. So as long as you have extra measures and you can confirm that information, that would make it convenient for existing financial institutions. They can use IT to do their due diligence. Well, after this amendment, I'd like to ask, what's the difference between A and B then? B just refers to extra measures. You suppose supplementary measures. But A just says just check on whatever you already have. So what's the difference between A and B then? You cannot say that it's a supplementary measure. There is a difference. Let me hear me out. Under general circumstances, we have to ask the customer for the ID. Typically, the customer will provide their ID according to 9A. The information that hasn't been presented, that hasn't been used for verification, that has to be submitted. So let's say I submit a passport, a travel document, or a driver's ID. And in B, it says you can take supplementary measures to verify information to supplement A. So in other words, they can use the credit rating platform, or let's say facial recognition, voice recognition. They can send their picture, and we deem that as a supplementary measure. Well, wait a second. You say B is relaxed, when in fact it's not. Think about it. B just says that taking supplementary measures to verify information, to taking to verify information relating to the customer that has been obtained. You already have obtained something, so you're asking for something more. The reason it's relaxed is because in B, all information, but the thing is it has been submitted. If they didn't submit anything, you have nothing. You can say I don't require that information, but if you don't verify the information, you have not done due diligence. But if you only have a limited amount of information provided by a client, that's all you can work with. I don't think you have I did not make myself clear just now. So if we look at 9, it says if a customer has not been physically present for identification purposes, for due diligence, the regulatory regime can do at least one of the following. And the choices are, they can use, let's say, a driver's license, which wasn't used before, or you use supplementary measures, such as a third-party credit rating agency. That's an option. And when we remove the word all, we have provided even more flexibility. Well, you might be worried that when you say all the information, you might be talking about boxes and boxes of information. So now it would have to depend on what you have received. If you received a lot of information, it's very complex. If you receive information within your authority, and if you don't check all of it, you'd still fail to to do your job. Let's say Mr. Toe is a special customer. We already looked at his ID, and let's say we need to take supplementary measures, so we might have to go to a professional credit rating agency to see if Mr. Toe, we find that his past record is very good, and we can rest assured and conduct business with him. So that B gives us the flexibility. Well, this 9B, it says, aside from further verifying the customer's identity, and in B it says taking supplementary measures to verify all the information. Now that has been crossed out. So does that mean that we don't have to verify all the 100 items that we had collected in the past? So we just need to verify the identity. But you're talking about information obtained. You're not talking about some of the information obtained. Why? In bracket B, in small b, it says taking supplementary measures to verify all the information. That was the old wording, and now they have amended that to verify information relating to the customer that has been obtained by the financial institution or the DNFBP. So the word all has been removed. If you have a lot of items, n items, and you have one or some items that can verify the customer, that would suffice. You don't need all n items to be verified. This is to help the industry. Well, that's how you would read if you compare to the old wording. But you can rephrase it such as to read as to verify some of the information obtained. Well, if you have the time, you can verify all n items. Well, I think this is just a textual description. No, but the government said that's not how we read it. So what is the government's stance? 9B is a relaxation of the wording. We want to deal with the previous wording of all the information provided. That was a large burden on the Institute. So we wanted to remove the requirement to verify all the information. So if you look at the ID, the driver's license, the third-party credit rating agency that indicates he's got a good credit rating, that is sufficient. We don't want to dig through all the customer's information. I agree with your policy intention, but you have to consider whether it is sufficient to verify the customer's ID. I am worried if that is your intention, even though that's how you've answered the legal advisor, but I'm not sure what some busybodies, they might harass the banks. You can go think about it, see whether it's necessary. Legal advisor. Well, if the government policy intention was to not verify all the information, just having one or several items would be sufficient. So for clarity's sake, could we just say any information? Add the word any? Would that deal with it? They can think about it. They can, yes, we can consider that. Then we can move to page 113. That's part 2, a miscellaneous amendment. What about 104, page 104? How come we've jumped to 113? Well, a lot of the amendments, we have just extended financial institutions to DNFPB. Okay, well, if we look at page 104, it's about wire transfer, only applicable to bank. It's not related to other people. It just says that if I make a transfer overseas, I have to collect the recipient's information, the originator's information. The law does not require recipient information. So if we look at the FATF requirement, they want the recipient information to be recorded, and the industry is already doing that. So we're taking this opportunity to clarify it. And so aside from the originator, the recipient information is also needs to be recorded. This is not a UN requirement. It is. I wish you good luck then. That's the FATF requirement. That's the FATF textual requirement. Well, I'm saying 3A, you're saying it's to a certain extent, it's a relaxation. It's not applicable to $8,000 or below. So the current banking ordinance is that for $8,000 or below, they also require recipient information recorded. Or is the 3A is a new addition. Well, if this is just an addition to our bill, the MA, well, it's an addition. If it's an addition, it's new. Well, the industry practice, they're already doing that. They record the recipient information. It's reasonable. I'm saying 3A, is it a relaxation? But it's not required for $8,000 or less. That is just a FATF requirement. So the FATF, is it a relaxation and therefore we're relaxing it? There wasn't a recipient requirement, and on this occasion, in 2012, they had made an amendment. So we now, I understand that's for D and E, but not 3A. It's the same. 3A also says that yes, we're just aligning with the UN FATF requirement. Okay, let's continue. On 113, we are talking about relying on an intermediary to do due diligence. We have to thank Mr. Toh for his opinion. We have taken it on board. We allow DNFBP to also rely on intermediaries to do due diligence, and we will put forward a CSA later on. And then 118, the archive requirement, the record requirement, it's 6 years. After taking on Mr. Toh's opinion, we have changed it to at least keeping records for at least 5 years. So DNFBPs, they can do, they'll keep records for at least 5 years, and if they wish, they can do more. So that is Schedule 2. Then we move to Schedule 3 on page 122. Schedule 3 says that the registrar's fees for registration. In 3A, we added Schedule 3A. We listed all the different fees. On page 125 is Schedule 4. Schedule 4 is the review tribunal. These are technical amendments, including removing financial institution from the tribunal name. I have a question on page 120. Well, I think the government knows that we now have some lawsuits. A lot of them are in auditing, accounting. Let's say for the new 2A, 2B, let's say a law firm or accounting firm or its overseas branches, they have to do some work. Some information has to be sent to Hong Kong, but ultimately, because of overseas jurisdiction, this information might not be released, and the Hong Kong main office might be penalized. Now, have you considered that this is not just one industry's problem? We have cases on the mainland where there were auditing problems. There were some compliance issue, and they had to transfer some information, but the mainland did not allow for some information to be transferred, and they could not comply with Hong Kong regulations. So this would occur as well. This is related to FTSB work. Do you need to add some mechanisms to deal with this sort of problem?
Yes, the legal advisor has a question. That's right. Well, actually, not a question, but a supplemental information. 2A. Now, you were saying, what if the law does not allow? Well, it says that the law in the jurisdiction will have to be complied with. Oh, very good, very good. Excellent. That explains the question. Yes, page 125, Schedule 4. These are technical amendments only. And basically taking out the name of the financial institution, and that's page 126 in the English version. And also the terms of reference, and therefore we need an interpretation concerning the persons in the registrar. These are the specified persons, specified authority. Now, starting from page 128, Chair, hold on. Now, it says the Hong Kong MA and the SFC, these are the employees, and the registrar seem to be described differently. Are you saying that some of the heads of the departments are not actually civil servants and they therefore have different powers? How does this work, actually? Thank you, Mr. To. Now, for the SFC and the Insurance Authority, when we drafted it this way, we looked at the relevant ordinance, and in their own ordinances, they have used the term employee. Now, as for the registrar, and it is very clear that these are civil servants because, and their employees are civil servants. Otherwise, it will become too loose because the civil servants will also be subjected to regulations such as confidentiality requirements. Now, Mr. Chair, concerning the question, I think for the insurance and the authority and the SFC, they are statutory bodies, and according to the employment ordinance, their staff are employees. But this is not so for the government. Civil servants do not come under the employment ordinance, but rather civil service regulations, and they are civil servants. And this is defined in Chapter 1. And so this is about the employment relationship. Civil servants do not fall within an employment relationship definition. That is the reason. Chair, what about the situation as follows? For example, this includes all employees of the Insurance Authority and the SFC, right? Yes, these employees of the two bodies, the Insurance Authority and the SFC, it is not that every employee of these two bodies can conduct investigations. There will be specifications within these bodies to specify, let's say it would be the enforcement department, and of a certain seniority, only these employees can conduct investigations. As for civil servants, it is also true that only certain ranking of civil servants can conduct investigations because, after all, they require professional know-how and also relevant training before there can be any such duties carried out. Now, I think civil servants' definition is very clear because the others are regulatory bodies, including the SFC, the Insurance Authority, and their staff are employees and are not civil servants. But for the Customs Department, for instance, these are government departments, and the employees, or rather, these are civil servants who are their staff. Well, I understand, Chair. Now, for the Housing Department, for instance, for the orders that are issued by the engineers, that's one, but sometimes they outsource the work, right? And these are outsourcing companies. Then there may be certain routine work, for instance. Well, your policy intent is that there is no outsourcing at this point. Are you saying that even for routine work? Chair, that is correct. Yes, they will have to come under the confidentiality requirement. It is only then would the staff be allowed to carry out investigative work. That is, if they come under regulatory requirement. Well, Chair, these are all employees, right? Apart from the definition, a legal definition, it is quite clear or quite broad in the sense that in A, it says that these are people employed for certain purposes. For example, under the SFC ordinance. But here, it is so loose and so widely termed. Well, You cannot say that you hire a person just to execute or enforce this ordinance and to do nothing else. You cannot be that narrow, can you? No. Well, it says here employees. Then what about the janitor, the person who sweeps the floor? What about that person? That would still be an employee. Well, if the Hong Kong MA dares ask a floor sweeper to conduct investigations, are you saying that? I think you are being too, you're splitting hair, I think. I think if you want to write the law that way or draft the law that way, then I really am at a loss if that is the way you want to split hair. But Chair, if I may give you an example. No. If that is the way you want to draft the law, I mean, how can the authorities execute their work? I mean, for the record, Chair. There is the interception of communication law, and under that law, there are certain employees mentioned as well, and it is no, that is quite irrelevant.
You will find it in subsection 9 that at a review tribunal you can be heard through a representative. That is all that it means. It does not apply across the ordinance, just in this section.
或者我聽一聽啦。你講緊呢個代表咧，係咪即係代表
This representative you're talking about is representative on behalf of the registrar in going to the tribunal. Is that what you're saying?
OK， 咁如果舉個例，嗰個處長。
So if it is a lawyer who represents a registrar, and that would not be a civil servant, this lawyer, right? What about that situation? Well, of course, if you ask a DOJ lawyer to do that for represent the registrar, that's fine. But what if it's an outsourced law firm? Well, 9A is appearing in person, and then it goes on to say, yes, there can be lawyers, barrister or attorneys who can represent. Well, where do you see that? 3. It says, making a presentation. 9A3 is about the representation, and B is a barrister or the solicitor, non-civil servants. So you're saying that's a separate item. It's a separate item. Is that what you're saying? Ah, I see it. Fine. Because there's a separate B there. Well, I didn't see B. I didn't see it. All right, now I see it. So your problem is resolved. Is that right? Yes, indeed. So don't say my questions are useless. Well, the reason why you had the question is because you didn't see this section. Well, Chair, it is not every member who can see all the sections and answer questions, as long as the question is resolved. So good, this question is resolved. Chair, that is why I had to ask a question, right? Yes, so the question is answered. Let us go to page 128, Chair. Yes, before we go to clause by clause, can we go back to what we have discussed in the last meeting? 53 T and S. Now that is on page 48 onwards. And that is without the written approval of the registrar, there cannot be a partner or director of the licensee. Now the question is, the person cannot hold such posts. But on the other hand, if the person acts in that capacity, what then? Even though the person does not hold those posts. We posed that question to the administration last time. What's the answer? That is to say, the person is acting as if he's a director, even though he does not hold the post. What about that situation? Right. If we look at the bill, the partners or the directors, they will have to be responsible. And also the requirement is that there is an ultimate beneficiary behind the scene. We will also have to look at whether that person is a fit and proper person. So if the situation does occur, as you have mentioned, that there is someone behind the scene controlling the situation, then in this situation, we will also have to see whether this person behind is also a fit and proper person. Well, fit and proper is one thing, but in Section 53 here is that you don't even know about the existence of that person. Of course, without your approval, and the person is a director, then that is illegal. But on the other hand, if he does not even tell you that there is such a person, and he's not a director, what then? Well, if the person is not a director, and he is a person behind the scene conducting that those actions, then he falls into the interpretation or definition of a beneficiary. But it doesn't say that the beneficiary conducting such actions would be falling foul of the law. It's not caught in your net now. Now, I think you should go back and think about it. Think about or maybe there's a criminal ordinance or offense that that person would have fallen foul of, then explain to us in the next meeting. Part 3, amendments to regulatory ordinances, etc., and consequential amendments. 1, subdivision would be amendment to the Professional Accountants Ordinance, and then there will be the Estate Agents Ordinance. And this goes on to, for the Accountants Ordinance, it goes on to page 136. So all the mechanisms concerning discipline, etc., investigation, these will be applicable. So this is just to include the money laundering, anti-money laundering reference into the ordinance. Yes, it goes on to page 136 from page 129. Chair, the way you draft it, under A or B there, as a certified accountant and as a corporate director, I think this is quite onerous. I mean, my question is, what is a reference point? In our existing laws, what laws would go to this level of onerous responsibility? You're saying cause or allow. Cause or allow. Where is it used? Caused or allowed a breach. Where is it used in other laws? Or is this a standard test for any corporate director? This is a golden formula? Or are there other ways of drafting in other laws? Now, in Criminal Procedures Ordinance or the Employment Ordinance, where it talks about a corporate falling foul of the law, whether the director is liable, it may say consent or connivance, and that may not be the same as how it is drafted here. That's exactly why I asked the question. Is it in line with FATF prescription, I wonder? Ms. Zhang or anyone on your team can answer this question, please. Thank you very much for the question. Now, for cause or allow a breach, this reflects the responsibility of the director. the director of a corporate is a senior management person responsible for conducting the affairs of the corporation, and if he caused the breach, this is very serious, or if he is in the know and allow the breach to happen, this is also a very serious and obvious responsibility. So what we're saying here is that the requirement needs to be high here. Now, Chair, this is a very technical question. Of course, the person should be penalized under such circumstance, but I'm talking about the terminology here. From memory, also, as the legal advisor had said, the company's law had used those two terms instead of these two. So you're choosing to use these two words or terms. How is this different from what it was before? Because there had been numerous precedents for companies' ordinance. All directors of corporates know about those precedents. Now you're introducing two new terms. And I don't think that is good, unless you're saying that this is different from the company's ordinance. And the numerous precedents of the company's ordinance is just way too low. And therefore, you have come up with a new wording, with new wordings, because these bring on new standards. If that is your intent, then this is fine. Or if you're copying from UN FATF, that's another matter. But on the other hand, if our existing law can adequately take care of this, why don't you transport the existing wording to this law? Now, if you have not prepared for this answer, because this is technical in nature, come back in the next meeting. Thank you, Mr. To. We will come up with a written submission citing the other laws with this wording. So, from page 137 onwards, or 136 onwards, it is about the, or rather 138 onwards, it is about legal practitioners' ordinance. So again, the relevant investigation and disciplinary procedures, etc., can be followed, and we've had discussions with the Law Society concerning 9A. We will have a more clear and even clearer amendment, and that will we will propose that in the clause by clause later on. And then we go on to page 140, Estate Agents Ordinance, and it goes all the way to page 145. Again, for anti-money laundering clauses, the existing disciplinary procedures, etc., can hold. So no problem there. We go on to page 147, and this is about the registry trading fund. And basically, the amendment here is that the licensing is also included in the content of the trading fund. And it goes on to the insurance ordinance on page 148 onwards. These are highly technical in the pages following in terms of the amendments. There is the mention of the anti-money laundering and also the tribunal, and these are purely because of these wording to reflect the content of the ordinance after amendment. Question, Chair, for page 147. On cost recovery, there are a few considerations. One, whether it is licensing, if I need to provide more regulatory service, then I may have to hire more hands. Well, I do not know about other scenarios, but let's say there's an 80% or something. You may have certain level in your mind. But on the other hand, if it is not in the same proportion, by adding this, there may be people who may oppose this because by adding this responsibility, this investigative or inspection responsibility, as a result, more costs will have to be subsidized. And therefore, there may be people who will criticize this, saying that by adding that function, the licensing fee will have to be increased, and it is therefore unfair. Therefore, what is the budgeting for this fund, please? And would it result in significantly increasing the licensing fee?
Or will you have a pro rata for charging these companies? Administration. Thank you, Mr. James Teo, for raising this issue. Mr. Teo, you need not worry, because we have over 100 and over 1.3 million companies on the registry. However, the cost for operating this new licensing system, the accounts will be separated from the current accounts. There will be no cross-subsidy. So the operating cost of the licensing system will be recovered on cost recovery basis. So the cost for operating this course will be recovered from licensees. The remaining 1.3 million companies will not be required to subsidize the operation of the system. All right, I heard a fact from you, and there will be no cross-subsidy between the two operations. Then I'm afraid that the cost, the fees you're going to charge on licensees will be very high. Now, for the 1.3 million companies, due to economy of scale, the fees are not too high. But here, if the number is small, I'm worried, because those professional inspectors can be very costly to hire. And of course, for HSBC Trust, I won't pity it, because its charges are high. But for instance, if we have small company on Lockhart Road, or someone operating with just a computer, then the fees will be exorbitant to them. I don't think that will be the case, because the costs will be calculated according to recruitment of civil servants. Our estimate is that we need another 60 staff members to implement this scheme. Can you tell me briefly what will be the cost involved? I can't remember what page it was. Page 123. Perhaps you didn't notice. We've already got a schedule on fees, but that is not significant. You're worried that the fees will be too high, but if you look at page 123, you can see the schedule of fees. What page number? 123. Page 123. You raised the issue that the fees might be very high, but how much are we talking about? Please refer to this page. Can the administration elaborate on this to assure Mr. James Teo? Schedule 3A, yes, page 124, Schedule 3A. The fees are rather affordable. Now, for applying for a license is $3,340. We don't expect. No, I really have a view. Now, for HSBC Trust, 3,400, that's fine. But of all companies, all such companies, not because they have to pay another $3,400, that is too much. Allow me to supplement. $3,400 would cover a 3-year period. It is not an annual fee. 3 years. All right, that's better because a license is valid for 3 years. So the administration should explain clearer to allay Mr. James To's concern. Oh, 3 years? That's better. That's better. You should not just say 3,400. Though it's about 1,000 per year. All right, 3,400. That's too much. If you had told Mr. Toad that it was 3,400 for 3 years, he would have reacted very differently. You have to bear in mind that once they have set up a trading fund, listen first. Of course, once they have extra manpower, they will have the pressure to amend Schedule 3A, and of course, LegCo can still be the gatekeeper. But I am worried. Now, you've already fixed the fees. That's better. I think you are cross-subsidizing them because if the number turns out to be different from your projection now. All right. No, I have to voice out this concern because I'm really concerned. I'm not from the financial sector, but when it comes to cost recovery, did you take into account that fines could go into the trading fund? Of course. Oh no. They were shading. They were shaking their heads. Okay. I don't think they would do the costing exercise this way. All right, doesn't matter. We still have Schedule 3A, and that is another safeguard. All right, page 148, consequential amendments to other ordinances, covering the insurance ordinance from page 148 to 152. 153, and then page 154, post office ordinance. There is no amendment to the insurance ordinance. Page 150, FA, references to the name of the ordinance and also the tribunal amendment here. All right. I was looking at the left-hand side. All right. Some terms have been scrapped because I've always been looking at the left-hand side. Page 154, post office, again. And they are just the same. 154, banking ordinance. All right. The references, some amendments to references to the terms. And then, starting from 158, Securities and Futures Ordinance, similar amendments, all the way to 165 or 67. All right, page 169, Schedule 1, again, the Securities and Futures Ordinance. And page 169, Payment Systems and Stored Value Facilities Ordinance. Amendment to the name of the ordinance. And lastly, page 172. Also an amendment to the reference to the ordinance, and that has completed the scrutiny of the bill. We don't have further questions. We still have about 2 hours. Can we deal with the CSAs as well? For sure. So following Mr. James To's usual suggestion, we should take a short break at this point. Yes. All right. And now we take a short break and then we continue with CSAs. 5-minute break.